Okay, good morning, everybody. Thank you again for joining us this morning for another installment of the Prestige series of COVID-19 webinars. My name is Jason Flynn. I am the Director of Human Resources and Client Services for Prestige Employee Administrators. If you've been following along during the webinar series, then who I'm about to introduce shouldn't come as a surprise. Our tax manager, Carol Sawyer, joins us again this morning, along with Andrew Lubash, who is the principal at Prestige. As we've mentioned in the past webinars, Andy Lubash has been involved with NAPIO for many years and is the current chairperson. We'd also like to welcome back Seth Prorate, who is a principal at the Groom Law Group. It is certainly nice to have all of them with us and the insight that they bring us from NAPIO and the industry and Capitol Hill as well. So thank you all for joining us this morning on the webinar. As for today's agenda, Andrew and Seth will be kicking things off this morning with some legal updates as they normally do. The focus today will revolve mostly around providing an overview of the Paycheck Protection Program Flexibility Act and the PPP Act implications for borrowers. Then, after discussing some expected next steps from the Treasury, SBA, and lenders, we'll wrap up with a Q&A session that includes many questions that have come from our very own webinar attendees around the loan forgiveness process and return to work protocols. As a quick reminder, all participants will be muted throughout the webinar. However, if you do have a question, I urge you to use the Q&A feature within the webinar and direct the question to the panelists. Of course, as we always do, we'll do our best to answer all the incoming questions. Anything that we aren't able to answer, we will get back to you with an answer in short order. Also, a copy of the presentation will be available in the COVID-19 Resource Center of the Prestige website following the webinar. So at this point, as I always do, I'd like to turn it over to Andrew Lubash, who will take it from here. You're on, Andy.
Thanks. Good morning, everybody. Again, thank you for attending our series of webinars. Topics seem to be changing a little bit, but I guess for now we're going to be, we're going to be finishing the series on the PPP forgiveness for now, and then as things change, we'll be including them in future webinars. As for those that have been on the calls prior, as you can see, Seth really is pretty good. All right. I could keep saying nice things about Seth, so he can keep saying nice things about me. But like I said, I've known Seth for at least 10 years, and his wealth of knowledge and the way he presents it is invaluable. Again, things have a little bit has happened over the last week. Again, as I mentioned in the last webinar, the focus is a little bit shifted due to what's happening in the world on a number of different fronts, a bit away from the PPP loans and coronavirus. Back to work, obviously Black Lives Matter, and other issues as well have been presented. And again, executive orders seem to be being signed frequently. So there's a lot changing. But again, we probably will see another push with regards to stimulus after the 4th of July is what we are hearing. But instead of rambling on and taking up your time with my nonsense, again, I just want to make sure everyone is aware that I am accessible. Many of you have called me. My direct line is 917-258-0223. That will get right to my desk and bypass the Prestige switchboard. And my email address is alubash, A-L-U-B as in boy, A-S-H, at prestigepeo.com. And lastly, my cell is 516-680-5021. Again, feel welcome to contact me with any questions or anything that you may need some advice on. We are here. We truly appreciate you. And without any further ado, I will hand it over to Dr. Prorate.
Well, thank you very much, Mr. Lubash. I really appreciate it. Happy to be with you all again this week. As fast as we try to give you information on updates, it appears the regulators in Congress like to make things even faster. Today, we're going to talk about the Paycheck Protection Program Flexibility Act, the PPPFA. It greatly, I think, well, I don't say greatly, it has the potential to have greatly liberalized rules for borrowers, and I think it's going to have some pretty significant implications for borrowers as well as lenders and Treasury SBA. We're going to talk about sort of how you can use the loan, as well as how you go about calculating forgiveness in light of some of these changes, really designed to make sure that, I think from Congress's perspective, designed to make sure that you can maximize the extent of both loan use and forgiveness of those loan amounts. But as we are preparing to talk about the PPPFA, just this morning, Treasury SBA came out with a series of what are basically loan forgiveness application EZ forms. Think 1040 EZ. I haven't even had a chance to dig into them yet, but based on a very quick glance, what they're going to be is for use by certain types of borrowers who effectively don't need to worry about whether or not their forgiveness amount has been reduced as a result of salary reductions or headcount reductions. There's also an EZ form for sole props who don't have any W-2 employees. I suspect we may talk about this in the future, so we're not going to talk about it today, but it is something that is, as I mentioned, the regulators in Congress continue to seek to refine the PPP program, as well as to sort of put out helpful guidance, but it does make it difficult from our perspective, and certainly yours, to stay abreast of everything that's happening with respect to the Paycheck Protection Program. Moving on now to the next slide. What we're going to do is there's a couple slides that gives you background on the PPPFA, the Paycheck Protection Program Flexibility Act. This is that second piece of legislation that was passed by Congress. The next slide here lays out some sort of details and background on this new piece of legislation. It was initially passed by the House on May 28th. Several senators had proposed their own bill with the House on recess through the end of June. The Senate ended up moving forward with the House version. So the House version is what was actually enacted into law and signed by the President on Friday, June 5th. So this is a very recent development. This piece of legislation really grew out of concerns by Congress, both in the House and in the Senate, and both among Republicans and Democrats, that some of the ways that Treasury SBA was interpreting the Paycheck Protection Program was not in accordance with what Congress had hoped for, and certainly in light of sort of the ongoing duration of the pandemic, something that perhaps there needed to be some expansions or additional relief. So there are several notable provisions in the PPPFA. On the next slide here, we sort of highlight them. And we're going to walk through these individually on subsequent slides, so don't panic here if you don't sort of understand everything on this slide. What I really want to highlight are those first two bullets in red. And we're going to talk about both of those today further, but these are really two of the most significant aspects of this second piece of legislation. The first significant change is it allows borrowers to either use the existing 8-week or 56-day loan forgiveness covered period that we talked about, right, when we walked through our 3-part series on completing the application. You can either use that 8-week loan forgiveness period, or you can elect to use the alternative covered period, which is equal to basically the earlier of the close of 24 weeks from the loan origination date or December 31st of 2020. This is really designed because there were some concerns among various borrowers that they didn't have enough time to use the loan proceeds, and that they would continue to have need for the loans and to use those loan proceeds. And so Congress sort of gave borrowers the ability to use, instead of that 8-week loan forgiveness period, that sort of extended alternative covered period of the earlier of the close of 24 weeks or December 31st. This raises a lot of interesting questions, which we'll talk about on a couple slides. So while there's an important element of additional flexibility for borrowers, there could be some aspects of this that you should consider depending on how SBA and Treasury interpret the PPPFA before you jump into using, say, that 24-week extended covered period. The second really important thing that it did was, as you guys may recall, this was a hotly contested interpretation by Treasury SBA. When the PPP was enacted as part of the CARES Act, there was no requirement that any percentage of the loan proceeds be used on eligible payroll costs. So in theory, a borrower could have used 100% of the loan on non-payroll costs and received forgiveness of that full amount. Treasury SBA interpreted, based on sort of, I guess, legislative intent behind the Paycheck Protection Program and perhaps evidenced by its title, they interpreted the rules as requiring a 75% of your loan be used on eligible payroll costs. What the PPPFA does is instead of 75%, it reduces that use requirement to 60%. So now up to 40% of your loan can be used on non-eligible payroll costs. We'll talk a little bit more about this rule because it also raises some interesting questions, but generally good news from how SBA and Treasury have interpreted the new 60-40 rule. All right, so moving on to our next slide here. I want to talk very quickly about some implications that you guys should be thinking about as we think through, as a borrower, whether or not to avail yourselves of some of the relief provided for under the PPPFA. So as we discussed, the Act is intended to liberalize numerous aspects of the Paycheck Protection Program. For example, not having to spend 75% of your loan proceeds on eligible payroll costs, and giving you the ability to utilize a longer period of time over which to incur qualifying expenses that would give rise to a forgiveness, i.e. really allowing you to maximize your forgivable amount. So for borrowers, these changes will likely require or result in you considering, gosh, do I want to use my PPP loan that way? So for example, if before you were trying to maximize your eligible payroll expenses to maximize your forgivable amount, and you were contemplating a one-time sort of extraordinary bonus that was not otherwise contemplated, well, while we're hopeful that those amounts are eligible for forgiveness because, quote, bonuses undefined are eligible for forgiveness, you might now not have to sort of take a potentially aggressive position because you could elect a 24-week period, right? So rather than have to pay a bonus or, hazard pay of a very significant amount, or, maybe you're trying to prepay wages to maximize forgiveness, to fit it all within that 8-week original period, you in theory have the ability to use this new extended period. And so in the theory that all money is fungible, maybe you disregard the bonuses or the really significant hazard pay, and you could just use regular base pay over the course of, say, a longer 24-week period. The reality, though, is that if you, depending on how Treasury and SBA interpret this new law, it could have some downsides if you elect that extended period. So remember, you guys have to sort of restore and maintain headcount for the duration of that forgiveness period. Well, if you've picked the 24-week period, does that now mean you have to maintain headcount and salary and hourly wage levels for the full duration of that extended covered period? If you elect that 24-week period, but you only did 12 weeks to sort of expend the loan proceeds and maximize forgiveness, can you apply within 12 weeks, or do you need to really run out that full 24-week period? Lots of questions we don't know the entire answers to. So, there are opportunities here, but, you may want to consider how you behave under the PPP and the PPPFA But at this point, we don't have all the answers, of course, because this law is only a couple weeks old. If you utilize, say, the new opportunities under the Paycheck Protection Program Flexibility Act, you're likely going to need new payroll and employment data for calculating your loan forgiveness. And, as mentioned, because as we'll talk about, not only is the loan forgiveness covered period extended for those who want it, so certainly are the safe harbor rules for those folks. And they may also be as well for folks who stick with that 8-week period. So the practical effect is if you want to utilize a safe harbor, either the FTE reduction safe harbor or that hourly wage safe harbor, you may need to look at additional periods of time for purposes of measuring your compliance with those safe harbors. When we think about lenders are probably going to want to reform certain loan terms to reflect some of these changes in the law. For example, we'll talk about the fact that the deferral period for principal, interest, and lender's fees has been extended. That's applicable to all loans, even those that were issued prior to the enactment of the PPPFA. They may want to issue revised loan documents. And certainly we're expecting, to the extent the lender is using their own application materials for forgiveness, they're going to be changing those materials as well, perhaps. As for SBA and Treasury, we're expecting them to issue other guidance in light of these changes. As we'll talk about, they've already begun to issue some of that guidance. But what this means is, while it's providing a great deal of additional sort of flexibility, it's also going to be a bit of a headache and certainly result in, borrowers having to think through additional sort of strategies and opportunities and weigh the cost-benefit analysis of certain of these liberalized provisions. All right. Now we're going to jump into the actual provisions in the Paycheck Protection Flexibility Act. And the first provision we're going to talk about deals with the deadline to apply for a PPP loan. So in a joint statement that was issued by SBA and Treasury, and this was on June 8th, this is the Monday after the president signed the legislation into law, they issued a joint statement. And on the next slide here, you'll see something they found that is pretty interesting. Even though the period of time under the statute was in theory extended to 12/31 for purposes of applying for a loan, SBA and Treasury, based on certain testimony by senators as part of the enactment of the PPPFA, have stated that June 30th remains the last day on which a PPP loan application can be approved. Meaning if there are any folks out there who have not gotten a PPP loan and they want to get a PPP loan, it needs to be approved by June 30th. So you may read in the press that the loan application date was extended to 12/31 of 2020. That is not correct. The loan application period and the approval must happen before June 30th of 2020. Okay, moving on now. When we think about the PPPFA, it's important to keep in mind the effective date. So while the PPPFA was enacted and signed into law, almost 10, 12 weeks after the CARES Act, the effective date of all of these provisions, except for one, is retroactive to the date of the PPP. So these changes go back in time, and effectively we pretend they were in place back at the end of March, early April. The one provision that is not retroactively effective is a provision that would extend the maturity period for the PPP loans. And we'll talk about that on an upcoming slide. What are the implications of this? Well, it would seem to allow for liberalized rules and relief back to the date of the loan origination date. So, for example, with respect to the use requirement, having historically been 75% as interpreted by the regulators, and now would be 60%. as mentioned, it could certainly result in the reformation of loan terms and the issuance of new loan documents. So certainly work with your lenders, understand what they're planning to do in light of the PPPFA. Would not be surprised to see mandatory riders or other sorts of things stuck on as a way to reform the loan agreements to reflect the enactment of this new piece of legislation. Okay, moving on now to the next slide. So as we mentioned, one of the most significant provisions of this new piece of legislation is that the loan forgiveness covered period, the period of time during which you can incur expenses that are eligible for forgiveness, can be longer than the original 8-week period provided for under the CARES Act. So that first bullet there lays out what the original statutory language provided for. It was the 8-week period beginning on the loan origination date. SBA and Treasury, remember, for borrowers that use a payroll period frequency that is at least as frequent as biweekly, they can use that alternative covered payroll period for eligible payroll costs. Well, Congress was concerned, because they've been hearing a lot of concern by small business, that 8 weeks wasn't enough, that borrowers needed longer. So what the Act does is it extends or expands the forgiveness covered period until the earlier of the date that is 24 weeks after the loan origination date or December 31 of 2020. A borrower that received a loan before the PPPFA was enacted can elect to keep that original 8-week covered period. So you're going to be picking either between the 8-week covered period or the 24-week covered period, assuming you got your loan before June 5th. In terms of its implications, it should certainly make it easier for borrowers to maximize their forgiveness. That's both because they have a longer period of time to incur expenses, but as I mentioned, it may also allow a borrower to avoid having to take potentially uncertain or aggressive positions in characterizing certain amounts as eligible for forgiveness, because they can now just look into subsequent periods of time to find obviously forgivable expenses. The downside is it certainly creates some new questions. For example, let's say I don't need 24 weeks, I just need 12 weeks to maximize my forgiveness. Do I need to use the full duration? As we'll talk about in terms of the FTE reduction or the salary hourly wage reduction, if I have to use the full 24 weeks, does that mean that even after I've used up my loan proceeds by week 12, I still need to maintain headcount and salary hourly wage levels for the full duration of that 24-week period? It would seem to be the case, but hopefully we get some guidance from SBA and Treasury that is more pro-borrower, shall we say. All right, moving on to the next slide. As I mentioned, under the CARES Act, you could use your PPP loan on any allowable use. It was eligible payroll, it was eligible non-payroll. It'd be like mortgage interest, rent, utilities. There were lots of things that were not payroll that were and are eligible. But SBA and Treasury created a rule that 75% of the loan proceeds must be used for payroll costs, and that the forgiveness amount must be comprised of at least 75% of eligible payroll costs. Well, Congress was annoyed by that interpretation because they were hearing that borrowers were finding it somewhat hard to meet those numbers. So what the Act does, the PPPFA, is it imposes a 60% use forgiveness requirement on the covered loan amount, thus allowing borrowers to not only spend 25% of loan proceeds on non-eligible payroll costs, but up to, say, 40% of eligible non-payroll costs. On the next slide here, we highlight just a couple things. There had been some concern based on the statutory language that the way Congress drafted the bill that if a borrower did not use at least 60% on eligible payroll costs, their forgivable amount would drop to 0. That would be a much stricter interpretation than SBA and Treasury has adopted with respect to the 75% threshold that they had, imposed through regulation. Thankfully, in that joint statement, and as reflected in an IFR that was just issued very recently, if a borrower uses less than 60% of the loan amount for payroll costs during the forgiveness covered period, they will continue to be eligible for loan forgiveness. And basically, just like the 75% rule, what's going to matter is that at least 60% of the forgivable amount must be comprised from eligible payroll costs. So on the next slide here, we have an example. And really, if you understood how the 75% rule worked, the 60% rule works the exact same way. It's just based on 60%. So in an example here, Acme Co. receives a loan for $1 million. During the loan forgiveness coverage period, they spend 55%, or $550,000 on payroll costs, and $400,000 on eligible non-payroll costs. So under the old rule, so I shouldn't say current, say under the original rule, right, Acme Co. failed to spend 75% of its loan proceeds on eligible payroll costs, but they were still able to get amounts forgiven so long as the amount forgiven was comprised of at least 75% of payroll. So how do you figure that out? You take what they spent on payroll, $550K, you divide it by 0.75, and it showed that their maximum allowable amount would be $733,000 in change. Under the PPPFA, the same process applies, but instead of dividing by 0.75, you divide by 0.6. And as you'll see there, the maximum forgivable amount, while it's less than $1 million, because they didn't spend 60% on loan proceeds, 60% of the loan proceeds on payroll, the amount increases materially to $916,000. So good news for how SBA and Treasury are interpreting that statutory provision. All right, moving on now to the next slide. So it's sort of a positive, but it also might be a negative depending on how SBA and Treasury interpret this. But as you guys may recall, the CARES Act allowed a borrower to avoid a reduction in the forgivable amount that would otherwise result from a reduction in employee headcount if they could restore headcount by June 30th of 2020. What the Act does is it actually strikes June 30th, 2020 from the statute and replaces it with December 31st of 2020. So on the one hand, it gives people longer to get their headcount back up to December 31 of 2020. But I think one question is, if I want to avail myself of the safe harbor because I did reduce my headcount during the, relative to pre-pandemic levels, do I need to wait until December 31, 2020 to measure that restoration of headcount? Let's say I restore it and I'm back up and running by July 31st. Do I need to maintain that restored headcount until December 31st of 2020? Related to a prior question we discussed about the 24-week extended loan forgiveness period. Might I be able to seek forgiveness after week 12 rather than waiting all 24 weeks? Is it possible I'll be able to show restoration of headcount based on my forgiveness application date? As of right now, we don't really know, but how this rule is interpreted, if you are trying to utilize the safe harbor, it could really, let's say you think you're going to be back up by, regardless, it is something that I think, we need clarifying guidance on, but it is something that, potentially has a result of requiring that you would have to wait until after December 31, 2020 to seek forgiveness. if you wanted to avail yourself of the FTE reduction safe harbor, if you've got a measure restored headcount on December 31st. I think for many folks that would be incredibly frustrating. One other thing to note here is that while borrowers have the election of picking the 8-week covered period, because of the way the statutory change was made, it doesn't look like June 30th is the relevant date for folks who stay with that 8-week covered period, which is really annoying because let's say you restored your headcount by June 30th, you want to seek forgiveness. Presumably you don't have to wait, you don't want to, nor should you have to wait till 12/31 of 20 if you're using that 8-week covered period. Hopefully some of this will get spelled out and clarified and resolved in guidance. But so as of right now, we don't really know, for example, how this 12/31/20 date is going to apply for folks who stick with that 8-week covered period. Can they use June 30th if they want? Can they use 12/31 if they want? How's it going to work? Very similarly, on the next slide, they also struck the reference to June 30th with respect to the salary hourly wage reduction safe harbor. So as you guys may recall, under the CARES Act, if you had a reduction in salary hourly wages, that would cause your forgivable amount to decline. If you restored those salary hourly wages by June 30th, you could basically avoid a reduction in your forgivable amount. Unfortunately, or fortunately, the way the statutory change is, right, they struck June 30 and they replaced it with 12/31. So when you think about that, for folks who are utilizing the 24-week covered period, 12/31 may be applicable to them or make more sense for those folks, I suppose. For folks who are using the 8-week covered period, you're probably thinking, well, if I was able to restore my headcount by June 30th, I want to use that date. Can I? I don't think we know the answer. Many interesting questions on how these 12/31 dates will work for borrowers, both for those who used a 24-week extended covered period and those that are using that 8-week covered period. All right, moving on now to the next slide. As you guys may recall, SBA and Treasury came out with a series of exceptions to the FTE reduction factor. These are ways that effectively you wouldn't get dinged on your forgivable amount because of a reduction in headcount. Right? One was if you made a qualifying written offer to rehire someone and they declined. One was if the employee was fired for cause, or they voluntarily resigned, or they voluntarily requested a reduction in hours. So the Act creates an exception, and it basically allows the borrower to avoid a reduction in their forgivable amount if in good faith they're able to document that they weren't able to rehire individuals who were employees on February 15th, and they were unable to hire similarly qualified employees for those unfilled positions on or before December 31 of 2020. So if they can show that, they can claim an exception. Or if they are able to document an inability to return to the same level of business activity as such business was operating at or before February 15th of 2020. So if at the end of the day, you literally just can't get back to the same level of business activity because of events beyond your control, then you can also claim that exception. Obviously, we'll be looking very closely at how SBA and Treasury implement and interpret this exception. But another question remains, which is, will those other regulatorily based exceptions created by SBA and Treasury remain? We're very optimistic that this will be additive. So you see the plus and minus symbol. We're really hoping this is a plus, meaning in addition to those 4 FTE reduction exceptions that SBA and Treasury created in regulation, this will be another exception that can be utilized by borrowers. One thing that was very helpful is that in looking at the IFR, the interim final rule they issued on the 60% use requirement, they indicate in the preamble to that regulation that they understand that Congress's goal was to enact a law that would make the laws more flexible for borrowers, to allow borrowers to maximize their forgivable amount. And the SBA and Treasury were going to interpret the Flexibility Act with that as background or as backdrop. If they do that here, we would expect that all of the exceptions listed on this slide will continue to be available to you. All right, next slide. And we're getting close, guys, just 3 slides to go. One thing that the Act did is that it extended the loan term, but that's only for loans that are issued on or after June 5th. So for most of you, this probably isn't going to be relevant. SBA and Treasury created a rule that said the maturity period would be 2 years. The PPPFA said, nice try, Treasury and SBA. The CARES Act had said no more than 10 years, and you came up with a rule that said 2. So they said for loans issued after June 5th, the maturity period may be no less than 5 and no more than 10. But again, this is not retroactive. This is effective only for loans issued after June 5th. So if you got your loan before June 5th, your loan maturity period will continue to be 2 years. Okay, moving on now to our next slide. As I mentioned, one of the changes made by the law was they extended the deferral period, the period of time during which the principal payments, interest, and lender fees are deferred. It doesn't mean they're not accruing, it means they're deferred. And you'll see there the CARES Act said that the interest and fees and principal payment may be deferred for not less than 6 months and no more than 12 months. SBA and Treasury, I don't quite know why, came back and created a rule that said we're going to use 6 months. So not the most pro-borrower interpretation of the statute because they picked the lower end of that range, the lowest end of that range. Well, what Congress did with the PPPFA is they said, look, we're going to make lenders defer principal payments, interest on those principal payments, and lender fees basically until after the borrower applies for forgiveness. And the reason for that is if amounts are forgiven, that applies to not only the principal amounts, but also any interest that would have accrued on those amounts or perhaps, say, lender fees. So what this change does is it makes sure that for folks that apply for forgiveness soon after the end of the forgiveness covered period, that they will be able to maximize, that they will be able to avail themselves of the deferral without having to come out of pocket before that moment in time with any payments back to the lender. There is one thing here. If the borrower does not apply for forgiveness within 10 months after the close of the forgiveness period, let's say, they have 24 weeks, they elect the 24-week covered period, they go 24 weeks, they wait 11 months after the close of those 24 weeks to apply for forgiveness. What that means is that after the close of the 10th month after those 24 weeks, the lender doesn't need to allow for the deferral anymore of principal, interest, or fees, and could begin to assess those against the borrower. All right, here. One last thing to know, and this is, I think, a really nice development for borrowers. As you may recall, there was a provision in the CARES Act, and this is on the next slide. And basically what it said is that borrowers who have PPP loan amounts forgiven, they're not able to use the Social Security employment tax deferral provision included in the CARES Act. So you may recall the CARES Act allows employers, with respect to the employer share of payroll taxes that are accruing sort of between the date of the CARES Act and December 31 of 2020, employers are generally able to defer those amounts or to defer 50% of those amounts until the end of 2021 and the remaining 50% until the end of 2022. So it really gives you quite a period of time to defer having to pay those employer's share of the payroll taxes. SBA and Treasury, but the CARES Act did say that if you have amounts forgiven, you can't take advantage of that deferral provision. So if you are going to get your PPP loan amounts forgiven, you won't be able to avail yourselves of that employment tax deferral. SBA and Treasury actually came out with a pro-borrower rule, and they said that prohibition or restriction only applies to borrowers, and it only applies to taxes after the forgiveness date. So for employment taxes due and owing before the forgiveness date, those amounts can be deferred. Well, Congress came along and said, look, we don't really care whether you get amounts forgiven or not. We want you to be able to avail yourselves fully of that deferral provision. So borrowers who get amounts forgiven, don't worry, you can defer the full amount of employment taxes just as well and as long as any other folks who didn't get a PPP loan. This is obviously a good change for borrowers, and I think one that most folks will be very pleased to see. So I think the takeaway from this, and I'm going to turn it back to our friends at Prestige, is that this law definitely has liberalized many of the rules. And it really probably will mean that for some of you, you're going to have to make some decisions. At minimum, whether to use the 8-week covered period or to use the extended 24-week covered period. You might also be thinking about, what eligible payroll costs am I going to use when I seek forgiveness? Because some are obviously eligible, maybe some aren't quite so obviously eligible. Certainly with respect to the 60% use requirement rather than the 75% use requirement, folks who thought they might not be able to maximize their forgivable amount in 8 weeks may now be able to do that because now a greater percentage of your forgivable amount can be comprised of non-payroll costs. As mentioned, there are a lot of questions that are unclear, which is how do those 12/31/20 dates work when we talk about the FTE reduction safe harbor and the hourly wage safe harbor? If you elect a 24-week covered period, can you seek forgiveness in week 12 or 13 or 14 when you've used all your proceeds? Or do you need to wait till 12/31? When you're measuring whether you're subject to an FTE reduction or a salary hourly wage reduction, are you going to need to be looking at and keeping all of your headcount and salary and hourly wages at pre-pandemic levels through the close of that entire 24-week period? We don't really know the answer to those questions at this point, and so hopefully we will know soon, and it will help inform some of the decisions that you may want to or be thinking about in connection with your own PPP situation. So with that, I'll turn it back to Carol and Jason and Andy and Eric, and thank you all for your time.
Thank you, Seth. As always, your insight is extremely valuable, as has been the past 3 months of the world here. We've been dealing with information coming at us fast and furious. As soon as we seem to have all the answers, they change all the questions. So we definitely appreciate your insight here today on everything CARES Act, and we do appreciate your involvement. So with that, Carol and I are going to go into some frequently asked questions, as we normally like to do. Again, these are based on a lot of questions that come through on the Q&A feature during these very webinars, but also from our clients throughout the week as they are calling into their designated specialists here at Prestige with questions on how to handle a lot of the different things, everything from the federal regulations to the Paycheck Protection Program, reporting, loan forgiveness, return to work. And there are a few questions here that we would like to go through with everybody. And with that in mind, we will start it off. So, this one's for you, Carol. Is the cap going to increase from $15,385 since the covered period moved from 8 weeks to 24 weeks?
The answer that's listed is going to be incorrect, or not completely correct, as they just released new guidance an hour and 20 minutes ago. The cap for wages, if the 24-week covered period is chosen, is $20,833, which according to the forgiveness application equates to 2.5 months of wages, which is essentially what you borrowed.
All right. Next question on the slide here is, how do I prove that an employee has declined an offer of employment? We called an employee to let them know that they will be brought back from furlough, but the employee's employment benefits were higher than their salary, so they declined and resigned from the company.
Well, you're going to want to make sure that you do as much as possible with this in writing. Possibly send a certified letter, certified return receipt request letter, and then ideally a written decline of the offer. That will probably be a little harder to get because the employee is not going to want to put that in writing. But we ask that you, if you're struggling with this issue, reach out to your HRBP and they can assist you further on it.
Yeah, and I can add to that. Listen, not returning to work because unemployment benefits are higher than the wages that they would be receiving had they, start working again is not a valid reason to remain on unemployment benefits. And in fact, they should be reported to the state. So I agree with Carol. Reach out to your HRBP, HR business partner to help work through these types of situations, and hopefully we can get these employees back to work. All right, next question we have here is, if you keep the 8-week period, does the new 60-40 rule for payroll apply?
Yes, the 60-40 rule applies to anyone who has received a PPP loan regardless of when they received it. And it's actually on the new application that has been released 90 minutes ago.
Okay, under what circumstance can an employer not use the safe harbor provisions?
The safe harbor provisions are not necessary if your 8-week average FTE count, or 24-week in terms of the new Flexibility Act provisions, if that is equal to or more than your FTE count for either of the look-back periods, which is January, February of 2020, or June 15th through June 30th, no, February 15th through June 30th, 2019, then the safe harbor is not needed. Your FTE count exceeds one of the two look-back periods. So there will be very many of the recipients of the loans that do not need the safe harbor provision.
Okay. Next question we have is there any information available for when the revised loan forgiveness application will be available?
Yes, just released less than 2 hours ago. You can email me. Those of you who know my email, it's csawyer@prestigepeo.com. I can email you the applications as they've been released. You can also, the way I found them at first was I Googled SBA Treasury new loan forgiveness application and was directed right to the SBA and Treasury site with those applications.
All right, moving on to the next slide. Question we have here is the forgiveness period the next 8 weeks after the date of funding, or any 8 weeks?
The covered period starts on the day that funds are deposited into your bank account. The only people who get to me, the only businesses to make a choice between using that start date and the date of the next first full pay period are those employers that pay on a weekly or a bi-weekly basis. Otherwise, for everybody, it starts the day, excuse me, that you receive the funds.
Next question states, loans funded after June 5th must use the 24-week covered period. If you received your loan before June 5th, you may still elect, or may you still elect the 24-week covered period?
Yes, you get to choose. There will be, I looked briefly at the new application. You're going to list what your covered period is, and it can be either of them if you received the loan prior to the PPP-FA.
All right, moving on to the next slide. If you move to the 24-week period, do you get to include 6 months of rent in the loan forgiveness calculation?
You can ignore the answer that's there because now the new application is out, and we know that the wage compensation per employee is limited to 2.5 months. I did not get to the point regarding rent, but if they're going to hold payroll costs at 2.5 months, I expect that rent will be 2.5 months, but please await further interpretation and guidance based on what was just released.
Great. This next one I'll take, Carol. The question asks, one of our employees has requested a reasonable accommodation because they live with a family member who is in a vulnerable population and are afraid of transmitting the virus to them. Do we have to accommodate them? You know, this is where in the HR world, it's difficult, right? It's a brand new world, and we are looking to help people as much as trying to also run our business. But the answer to this really is no, you do not have to. You are not required to accommodate them. The EEOC has confirmed that workers are not entitled to an ADA reasonable accommodation simply to avoid exposing a vulnerable family member to a potential case of COVID-19. Right? It's important to note that while the ADA prohibits discrimination based on association with an individual with a disability, that protection is limited to disparate treatment or harassment. Right? The federal disability rights statute does not require you to accommodate an employee without a disability or any disability-related needs of a family member or anyone else, right? So, I mean, obviously you have the ability to be flexible in these types of situations if you choose to. You'll want to be sure to remain consistent and not get into any discriminatory situations, but you are not required to accommodate an employee in this specific situation. Next slide starts off with our lease renewal was established before February 2020, but the renewal date is beginning May 2020. Can our lease renewal be included in the rent calculation?
A rent payment is a rent payment. You're experiencing that rent payment as a part of your ordinary course of business. So yes, it would be included in the forgiveness application.
All right. Can I require an employee to bring their own face mask to work, or should the employer be paying for the face masks that the employees wear? So if you do require employees to wear face coverings, then you as the employer should be paying for them. You know, many state and local orders actually specifically require that employers pay for the face coverings that employees wear, so it's important that you are in tune with your state and local orders, and this is something that you can also discuss with your HR business partner. Right? But if you are requiring these face coverings to be worn throughout the office, and you can't require employees to purchase their own, you should be providing them to the employees. Okay, next question we have here. For employees that process their payroll on a semi-monthly basis, can you begin the 56-day covered period on the day of the first payroll run?
Semi-monthly payroll schedules are not eligible for the alternate covered period. That is only eligible, or the only pay schedules eligible are the weekly and the biweekly. So for a semi-monthly payroll company, the 56 or 8-week covered period will begin on the day that you receive your funding.
All right, next question states, are we required to prorate either the first or last semi-monthly payroll as it doesn't fall neatly into an 8-week period?
You don't need to prorate the first one because the guidelines specifically say paid or incurred. So let's say you get your funding on May 28th and on May 31st you pay the May payroll. It's in a monthly payroll. All of that will count towards your forgiveness. At the end, if you have a couple of weeks, because I'm pulling up dates, so I'm not sure where the cutoff would be, but you are allowed to then include the few days that were incurred but not paid until the next regularly scheduled pay date. So there's no need to prorate in the beginning.
Okay, getting to the last couple of slides of questions here. This question states, if an employer uses the Paycheck Protection Program loan funds within the 8 weeks, should they choose to use the 24 weeks? And is there a benefit to extend to the 24-week period?
With the application that takes into account the 24 weeks just having been released, it's not really a question that can be answered. I mean, if you use your funds and you meet that 60-40 split and you don't have a headcount issue, it would appear that, based on that information, file the application with the 8-week covered period. Keeping in mind, we also now have that new EZ application that is much simpler to complete. So it remains to be seen.
Great. The next question revolves around what types of things can be used as a utility and what the interpretation is there. But the question asks, has there been any further interpretation as to what can be included as a utility, such as ADT services or pest control or things of that nature?
Yes, there has been no change in the definition, no additions, no subtractions in what utilities includes. It is the same language that was issued.
Great. So next question I'll take, Carol. Can we ask older workers, such as those age 65 and over, not to come into work because they are at a higher risk for a severe case of COVID-19 if they contract the virus? So no, the EEOC has indicated that this would be a case of improper age discrimination. The Age Discrimination Employment Act prohibits, as everyone may be aware, it does prohibit employers from discriminating against those employees age 40 or older, and therefore the law prohibits you from involuntarily excluding an individual from the workplace based on their age, being 65 or older, even if you are acting for benevolent reasons, such as protecting them from the virus. I can understand why someone might think about this. We've had conversations about this, and they always do come from a good place. But we have to be careful. We have to be careful not to discriminate, even if you think you're doing a good thing. So again, if you have any types of questions around this, or you're trying to plan or protect employees, reach out to your HR business partner, and they can provide you with the correct support. Really along the same lines, the next question asks, what about pregnant employees? Can we ask them to not come to work to protect them? Again, just like with older workers, you don't have the ability to involuntarily exclude an employee from the workplace due to their pregnancy. And again, even if it's coming from a good place or motivated by, good concerns, an employer cannot single out workers on the basis of pregnancy for adverse employment actions. This includes involuntary leave, layoffs, or furloughs. Furthermore, you may also have an obligation to accommodate a pregnant worker under the ADA. So these are all things to think about. Again, I know you're looking out for your employees, but we can't make sure it impacts their employment in an adverse direction. Okay, last couple questions we have here. I received an EIDL grant after the PPP loan. Should this amount be included in the PPP loan forgiveness application?
Yes, the forgiveness amount will be reduced by the EIDL grant amount that you received. Federal government's trying to limit how much free money they give you. There is a space on the application that you'll need to indicate the grant amount that you received, as well as your IDL account number.
And finally, will we be telling our payroll specialists which time frame we will be using, 8 versus 24, and which percentage, 60-40 versus 75-25, when they do our calculations, or can they do it both ways and we can decide which one is more advantageous?
First of all the loans, as we've discussed, are 60-40, so there is no choice there. We can provide you at this moment, and as you go through your covered period, with a report that lists the eligible costs in that payroll the costs that are eligible for forgiveness in that specific payroll. The FTE count is it's an average, and we won't know the average of 8 weeks or the average of 24 weeks until those time periods are over. And ultimately, the decision is yours. We're here to provide you with all of the information and the data that is withheld in the Prestige Pro system that you run your payroll through. Ultimately, the decision of which period to pick will be the responsibility of each borrower. We also suggest if you want to reach out to your CPA, they might be very well versed in this and be able to assist you as well.
Excellent. Thank you, Carol. And that wraps up our questions, question and answer period, and our webinar. So I'd like to thank Andrew, Seth, Carol for being involved in these webinars, and of course everyone behind the scenes that helps make these webinars go off each week. It's greatly appreciated. Just as a reminder, today's presentation will be posted on our COVID-19 Resource Center located at our website. The link is right there on the slide for you to view. We will continue to send out our weekly COVID-19 email updates, which is should be deployed later this week. And please stay tuned for an invitation for next week's webinar. As always, reach out to your payroll, HR, and benefit and compliance support team here at Prestige for any questions you may have. Visit the Prestige Go mobile app to link directly to those support teams. And should you be looking for any more information regarding COVID-19, everything related to that, please visit our Resource Center on our website. Thank you, everybody, for taking some time this morning to join us. Look forward to speaking with everyone again.